Hi, my name is Kathy Sabeda. I'm a mortgage planner and proud veteran. I'm here with Sarah Suda, a wonderful trust attorney who's going to help us with answering some questions on trust. Hey, Sarah.
Hi, Kathy. Thank you so much for having me on today. And yes, I am a trust attorney with the Law Office of David Foley. I've been doing trusts for about 10 years now, and I'm happy to be on to answer any questions or go through trust guidance with your clients.
Wonderful. So we're just going to do a couple of quick questions, and then hopefully we'll send this out to the for the people, and then hopefully we'll get some feedback, and then do another panel where we can be live and answer their questions so that they can get their trust. Period.
Perfect.
So when we're dealing with a living trust, people go out there and they say, "Hey, what does it really consist of?" Because you have revocable and irrevocable, and then it seems like you have this whole big package. So really, what does a living trust consist of?
Great question. So in our firm, the majority of our clients, when they're setting up a trust, that includes several pieces of estate planning. So the first and biggest is the actual trust. And the majority of those trusts are revocable living trusts. These are trusts designed primarily to avoid the California probate process and ensure that any of your property goes to the correct people via the correct trustee. So the correct person is administering that. In addition to the trust, when someone's doing estate planning with our firm, we also include something called a pour-over will, which basically is a short will indicating that all of your assets that aren't specifically part of your trust are intended to be part of your trust, as well as powers of attorney, and those include both medical and financial powers of attorney. A couple of other documents that are important as well. One is an assignment of your personal belongings to the trust. We also include some optional forms like designating particular items to particular people, as well as burial instructions. And then of course, instructions in general on how to properly fund the trust, because a trust that doesn't have anything in it is not that useful.
Great. Well, wonderful. So these individuals, some people say, "Hey, well, I already have a will." Yeah, but that's still not the same as having a trust, correct?
That is right, yes. So a will does not help your loved ones avoid the probate process. A will is just an exhibit that goes to probate.
So if a person owns property, then it's highly recommended that they have a trust in order to facilitate what the biggest thing that people forget is not only if you pass and no longer with us, but what if you become incapacitated? That's also one of the biggest reasons for having a trust, correct?
Absolutely. Yeah, that's a really good point, because otherwise, you perhaps don't have anything in place, but there is that time in cases where someone is still living and maybe going to be living for a long time, but they're not able to manage their financial affairs anymore. And the trust does put in place what you would need in order to handle that situation.
And so honestly speaking, it really is so cost effective to get a trust, because if you do not and you have property, it's going to cost you tens of thousands of dollars throughout probate versus just paying what you need to pay and investing in a trust. Am I correct?
That's right. Yep. When I look at those probate fees, they can be very, very hefty. So it's based on the overall value of the estate. And it's a sliding scale. So it's, I'm sure you've seen those numbers. It's 4% on the first $150,000 and then so on. But yes, I mean, it's rare for me to see a probate that doesn't have fees in the, $40,000, $50,000, $60,000 kind of range.
So what about people who have a trust, right? And it's outdated and they don't know who to go to either update it or get it revised. What would you recommend that they do?
So any estate planning attorney can update your trust for you. So just because you initially set up a trust with one office doesn't mean you have to continue with that office. So the idea is all of us as trust attorneys are writing trusts under California law. They should be valid under California law. Most likely, if you go to another office, they're going to use their own form of documents under California law, but anyone can continue to help you with your estate planning that is, licensed in the state of California to do that.
And then I think, well, just lastly, so let's say something happens and I can't find the original trust, but I have a copy of the trust. Then what do I do?
Yeah, so really, if you have a signed notarized copy, you're not in horrible shape. It is worse that it could be outdated or no longer says what you would want. But if you are concerned about that, then the best way to address it would be to what we call restate the trust. So a restated trust is essentially you're updating and redoing all of the documents, but you are retaining that original title to the trust.
And then for those families that the parents become incapacitated, then what happens to whatever's in the trust, right? Then that person has to follow through whatever their wishes are, correct?
That's exactly right. Yeah. So whatever the trust outlines, and generally speaking, when you have the trust, so the people who set it up are the settlers or the trustors of that trust. If they're living but incapacitated in almost all situations, then the trustee would just be using the assets to take care of those trustors and settlers, the people who set it up during their lifetime. So nothing is distributed to anyone until actually the trustors pass away.
Gotcha. And then if they don't have a trust and they become incapacitated, what do you do as a family member?
So if someone doesn't have a trust and they pass away, then you open a probate. So, it's a court, it's a process overseen by the court system. So if it's property in San Diego County, then you would open a probate with the Superior Court of San Diego County downtown, most likely. And that is just, you would have an attorney to guide you through that process.
So as an individual, I'm the one who has to actually open probate.
Yes.
Right? Or get an attorney. Yep. So then if the parents are incapacitated and they own property and they don't have a trust, then what do you do as a family member?
That's tricky. Yeah. Okay. So actually completely incapacitated, then they, like you said earlier, we discussed, they can no longer sign documents. So at that point, you're most likely looking at a court-sponsored process anyways. In the case that someone sees that coming, then I would definitely urge the family to, get the trust up, or at least, consider making property transfers to family members, something like that. But yeah, once, it's a formal incapacity, there's not much you can do.
And then last question for you, and that has to do with either guardianship or what happens to you if you have children and how can you manage it? Obviously you should have a trust. How does that work? Is that two different things or one and the same?
So any guardianship, which would be, so who would take care of your children if you passed away and they were under 18, that is addressed in our case, in our pour over will. So the pour over will is going to address guardianship. You're nominating that guardian. Guardians do have to go through a formal process through the courts. It's not anything like a probate. It's not that it's an expensive process, but the court does make sure that the guardian is fit. So they have some kind of background screenings on that for a guardian, if that actually happens. But designating the guardian's a simple process through the pour over will.
Well, Sarah, thank you so much for all of your answers. And what phone number can they reach you at?
So our number at the office is 619-284-2444.
Well, great. Thank you, everyone, and stay safe. We'll be getting back to you soon.
Thank you.
Bye.